the originalism and textualism, because of some of the concerns that you talked about, actually has been gaining a lot of traction in legal academy and within the law generally. It used to be kind of scoffed at in maybe the early 80s, and now I think it's really, even Justice Kagan, who's would not consider herself an originalist, but during her confirmation hearing said, we're all originalists now. And I think she's alluding to the idea that everyone coming before the court now recognizes they at least have to have some foothold in an understanding that this is what the text says. It used to be, 30 years ago, maybe, that you could come up and they would argue a case about a provision of a statute and never actually quote the statute. And which nowadays sounds like, wow, how are you fulfilling your oath to uphold the law if you're not actually even reading what the law is? Why is our legislature bother making this sausage if no one's going to even look at what they wrote and what they actually voted on and what the president signed? So I think we've come to a point where both sides, to a certain extent, recognize the necessity to look at the text and to make an argument from there. I just think there's certain approaches and the challenges, and this is something Justice Scalia said, that once you open the door to having to kind of evolving the Constitution into something else, then it's very hard to separate just your own personal politics or your own personal views on things from where you're evolving it. So are you really interpreting the Constitution anymore? Or are you just kind of reading your own desires into it? And what Scalia said is, if we're doing that, then it's no surprise that we're going to be treated like politicians in our confirmation processes, because effectively you are voting for what I believe and what I think in my heart of hearts, not just my effectively, my legal ability and my ability to read a statute and interpret it.